Hearing in the appeal, Commissioners for His Majesty Vermilion Custody against Vermilion Holdings.
Mr. Ghosh. Good morning, my lord, my lady. May it please the court. I appear with Mr. MacLeod and Mr. Alexander for the Crown, and then the friends, Mr. Simpson and Mr. Pett, appear for the respondent. The issue before the court is whether this option granted in 2007 by Vermilion to Mr. Noble is an employment-related securities option within Section 471 of the Income Tax, Employment and Pensions Act 2003. And with the court's permission, I'll adopt the submissions I made in my written case. And please, may I take my submissions in the following order. 1, I'll make my submissions on the facts which we say are relevant to this case. Then I'll make those facts good by showing the court the relevant documents and the decision of the first-tier tribunal. 2, with the court's permission, I'll make my submissions in Section 4711, and these two alternative tests of what by reason of employment means, whether it's a but-for test or whether it's something other. What is it that permits, in this case, the acquirer of the option to enjoy that option? 3, I'll make my submissions on the deeming provision, Section 4713, and here the revenues case is very simple. The grantor of the option was Vermilion, the employer. It's axiomatic that they made the right or opportunity to acquire that option available to the recipient, to the acquirer. That's axiomatic. And whoever else may be said to be also perhaps a candidate person for making that option available, that's irrelevant. On any view, the grantor of an option makes the opportunity to acquire that option available. And 4, with the court's permission, I'll have shown by then the court, the first-tier tribunal decision, and with the court's permission, I shall take the upper tribunal and the decision of the division short. I've set out in my written case why we consider the upper tribunal to be right on Section 4711 and why we think the majority were wrong on 4711 and 4713. So please, with the court's permission, may I make my submissions on the facts? 1. Before December 2006, there was a company, Quest Corporate. It supplied corporate consultancy services to Vermilion. 2. Some of the fees for these services were paid not in cash, but by the grant of this 2006 supplier option. The option was granted to Mr. Noble, not Quest. It was granted to his nominee company. But it's common ground that the option was acquired by Mr. Noble, all right. In parentheses, there was a similar arrangement for some of the legal fees. It was a 2006 option granted to this law firm, Dixon Minto. 3. Come December 2006, Vermilion is in financial trouble. Mr. Noble was consulted, and what emerged was this financial rescue package where new money was to be put into Vermilion, a combination of debt finance and equity finance. And there was a blueprint followed by a more formal summary of legal terms of this rescue package. But relevantly in this case, there were 2 preconditions, at least 2. The first is that Mr. Noble was to become executive chairman. So nothing was going to happen unless that happened. So it wasn't good enough for these investors to put money into Vermilion, that Mr. Noble was going to carry on, whether it was him or the company, Quest, providing services as a consultant. They didn't want that. They wanted Mr. Noble to be the executive chairman, and he got a contract of employment. And that was in March 2007. There was another precondition, that Mr. Noble's 2006 supplier option, and bracket, the same thing happened to the lawyer's 2006 supplier option, close bracket, was to be diluted. And please now flag, what actually happened was it wasn't a variation of the 2006 option, it was a grant of a new option, that's one. But also, and relevantly, the 2007 option, it had a term that was longer than the old 2006 option, but by which I mean this, they were both 10-year options, but when the time came that Mr. Noble exercised his 2007 option, he did that at a time, sometime between June and November 2016. He did that at a time when the old 2006 option would have expired. That would have expired in February 2016.
Was the longer term as a result of the date on which the option was granted?
Yes.
Yes, thank you.
Yes, ma'am. And the shares subject to the two different options, the 2006 option and the 2007 option, they were different. The 2006 option, well, it was over what it called ordinary shares. And I'll show the court the relevant articles in 2006. It's not at all easy to see what those share rights were. The company had an issue at that time, A and B shares, which were voting shares. The A and B shares were different. The A shares, on a conversion event which included a sale or a flotation, some of those converted into deferred shares. Not so for the B shares. So it makes a difference whether you had A or B shares. The option actually simply is in terms of over ordinary shares into which A or B shares would convert if there was a sale or a flotation. My next point is the 2007 option were over different shares, F shares. There were no F shares in existence at the time of the 2006 option. These are newly created shares. No votes, no right to appoint directors, and lesser dividend rights. I will make this good.
Again, would these shares convert into ordinary shares on a sale?
No,
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 they
my lord,
wouldn't.
no. They would simply be sold on a sale or on a flotation. And they needn't be sold. A sale is actually any event where more than 50% of the company is sold. So theoretically, they could have been kept, but they didn't convert.
Yeah, thank you.
And again, importantly, the last feature, when I'm still on this series of factual submissions on what I've called fact number 3 on this precondition, on no view in my respectful submission is the 2007 option payment for services rendered by Quest. Quest, the company, delivered services. They weren't paid cash, they were paid an option. So that is fructified. The functionality of that option is spent. It was payment for services. neither did the 2007 option satisfy the 2006 option. It wasn't a surrogate for the shares.
Was there any money that changed hands at the time of the grant of the 2007 option?
No, my lady.
Was any of Quest's outstanding fees paid off in cash?
The summary of legal terms said it should be. It does say that.
Yes.
We've got no finding either way. The FTT records that what was supposed to happen was that Quest's outstanding fees should be satisfied.
Yes.
What I suspect, this is speculation, so I don't. Let me say straight away, this is what I think must have been meant. Not all of Quest's fees were satisfied by the option. It was for additional work. So some of that money would have been payable in cash, and it may be that some of that cash consideration was outstanding. That might be what was meant.
Yes, it talks about, I think it talked about other services or other fees.
Exactly so.
So your understanding was that was in relation to non-option services, as it were. This was work not covered by the option conferred. And the net result is that because the 2006 option was in effect cancelled, Quest never got paid for the pre-2007 services.
I don't say that. That last bit is, that last tailpiece of my Lord Hodges' summary is what I quarrel with. They were paid. The 2006 option was payment. Was payment for those services.
So they got paid by the chance that the option...
Yes.
But then the option was cancelled.
It was cancelled, my lord, and what this case is interrogating is the circumstances of that cancellation and its and the grant of the 2007 option. And what this case is interrogating is, was that 2007 option granted by reason of Mr. Noble's employment? That's one. And what I'm saying, I say relevantly, is that the one thing the 2007 option wasn't was payment for those pre-December 2006 services. That option, I'm about to go on to this, that 2006 option, that was payment for the pre-December 2006 services. That was what was about to become worthless because of Vermilion's financial difficulties. So that payment was turning out to be bad. So you've got a new set of circumstances, financial difficulties, a financial rescue package, the precondition that Mr. Noble becomes a director. Those are the relevant factual circumstances that, in my respectful submission, one should bear in mind in looking at 4711 and 4713. But the one thing I say the 2007 option wasn't was payment for the 2006, the pre-2006 December services. That's happened.
So it's as if I said, well, somebody's going to provide me with some services, and I say, all right, well, I'm not going to pay you in cash, but I've got this lottery ticket for 2 weeks' time, I'll give you that, and you may get millions or you may get nothing, but that's how I'm going to pay you, and if somebody accepts that, then that's their payment for the services, regardless of whether the lottery ticket wins or not.
Exactly so, my lady. Exactly so. And what this case is about is precisely where the option or the lottery ticket is bad, here because the company's in financial trouble, and what's being said is, well, look, that payment is bad, or it's going to become bad. Come and work for us, and actually we'll give you something different, something other.
Yes, this is your take on the facts. Ultimately, we have to look to the first-tier tribunal's findings.
Exactly right, my lord. And what I'll show the court is that the first-tier tribunal's findings are, I'm trailing my submissions now on 4711 and 4713, but also on my submissions on the facts. Insofar as they are findings of fact, they don't hurt me. Insofar as the first-year tribunal has made descriptions, I will show you this, has made descriptions, they're what my Lord calls the take on these facts. They are one, descriptions which are mixed fact and law, and I've got quite, I will address you on the law. And two, and this I think is uncontroversial, even more so when I show you this, their conclusions ignore completely this appointment of Mr. Noble as director. I will make this good. They make the finding that this was a precondition, but what the tribunal goes on to say, and the court's read this, is, oh, the cause of this 2007 option was the 2006 option, nothing else. Pays literally no regard, no acknowledgement to the precondition of his directorship. It's not that they look at it and say, well, we'll weigh this. They don't do that. So my Lord is right. Of course he's right. The findings of fact I can only impeach insofar as they are infected by misdirection in law or they're vulnerable to Edwards and Bairstow, and we've taken an Edwards and Bairstow point.
Sorry, I missed that. You're taking the Edwards and Bairstow point, is that what you're saying?
Yes, it's in paragraph 35(2) of our case to say, well, look, it's a certain conclusions which we quarrel with are wrong because they're mixed fact and law, and what's more, they're vulnerable to criticism on standard Edwards and Bairstow principles.
Yes.
Please may I continue with my submissions?
Of course.
4. Mr. Noble agreed to this 2007 option because otherwise his 2006 option would become worthless. So there was a conversation to be had. Do you want to keep your 2006 option, which grants an option over 2.5% of these, what's going to become ordinary shares? He could have said no. Or, with this financial package where you become a director, will you take this 2007 option instead? And he said, yes, okay. 5.
The existence of the 2006 option gave him a bargaining position the other way around, didn't it?
Yes.
Because he could say, I won't give up my 2006 option unless you offer me at least something instead.
Yes. Yes, of course it did. He could have said no. We're not running away from that. What we do say is, nothing's going to happen. The prospect of your bad 2006 option turning into something better, something good, unless you become a director. So my response, my Lord, to my Lord Legate, is that's right. The 2006 option was a bargaining chip, but that bargaining chip is located in a financial package that says the company's going to become more valuable if and only if you become a director.
So you're saying we can't assume that the dilution down from 2.5 to 1.5 is detrimental, because you say the 2.5, on the face of it, would potentially be worthless.
I'm absolutely saying that, and I'm saying, in a sense, that's commercially obvious. Everybody, I think the phrase is, all the option holders were to take a bath. I mean, that's a phrase that crops up in the FTT's decision. Absolutely right, that to turn this company around, all the option holders had to at least consider taking a dilution. Lots of other things were going on. The old management, they had to leave. The court may recollect that.
But do you say that the 2006 option would have been worthless? It's because the company would have gone into the ground, but was it also because these ordinary shares to which it attached no longer existed? We may be getting into difficult territory of whether a company which has granted options over a particular class of shares can just then cancel all those shares and create new shares to which the option doesn't adhere. But
the company law on this is murky, my lady. It absolutely is. And there was quite a lot Mr. Noble could have said as a matter of company law. You can't do this. The A and B rights were actually in the articles. They were entrenched. The ordinary shares, you will search in vain for any specificity as to what those share rights were.
What the 2006 option actually attached.
Yeah.
Okay.
But having said all that, my big message is, look, this company is not doing well. One of the things that has to happen, amongst others, is that you, Mr. Noble, need to be a director with a contract of employment, with a minimum period that you devote each week to the company. In the same package, you've got an option. We all know you've got an option. Not 2.5. You'll have to take 1.5. He could have said no. He said, okay, I'll say yes. But both those features are located in the same financial package.
But I thought you were saying that if he'd said no, that would not result in him having an option over 2.5% of the F shares.
Oh, it wouldn't. No. It would have
So
been.
he would have had to have some new kind of option anyway. The question was whether it was going to be 2.5 or 1.5.
The financial package would have meant he needed. My lady puts it well. He would have needed something new anyway.
Given that they'd altered the structure of the classes of the shares, yes.
Exactly right, my lord. And what we're, as I've said now, what we're interrogating is, in a world where Mr. Noble, one of the critical preconditions is that he has to become a director, in that same financial package, this option needs to be changed somehow, on any view. Does that mean that this new option is an employment-related option?
Let me just push this a little bit further. So are you saying that if he'd refused, if he'd said, no, I don't really want to be a CEO, but here's my chum who's equally brilliant, and if he becomes CEO, he'll turn this round, and I'd rather he did the work, and I'll just stick with my 2006 2.5 option then, because I think the company's going to be turned around by something else, would he then have had an option over 2.5% of the more successful company?
My response to that, my lady, is we don't know, because that would have been a new financial package, a different financial package. They would have had to accommodate Mr. Noble saying, no, I'm not going to be a CEO, which was a precondition of this money coming in. So straight away, that's stumbling block number one. And number two, he's saying, well, and what's more, insofar as I've got remedies in company law, I'm keeping my 2.5 over these ordinary shares. So they would have had to, they being everyone else who was interested in the venture, would have had to go away and say, we need a new financial package now. And what that other financial package may have been, we don't know.
But I think what you were saying was that what his entitlement was going forward under the 2006 option was a little unclear in any event. Is that?
I do accept that. And I'll show you the option, but I've said it now, it talks about ordinary shares. So I think a little unclear is a fair way to put it. But the central point here is, if someone says, come and work for me, and as part of that same exercise, you've got an existing option, I'm asking you to give that up and take something else, something different, something other. That's the key question in this case, in my respectful submission. Does that something other come to Mr. Noble by reason of his employment?
Although it didn't in the case of Dixon Minto, they got something other, but no employment.
That's right, my lord. However, the Dixon Minto option may or may not be an employment-related option.
Sorry?
May or may not be?
An employment-related securities option. That's not this case.
Well, it's hard to see on your case why it wouldn't be, given that section 4711 talks about the securities option being available by reason of an employment of any other person.
My lord typically makes a perfectly good point.
Thank you.
And that's not an odd result. It's trailing something I'm going to be putting to the court later. Imagine I have a family company, and I am told, and I've got an option, and I am told that a world-famous business person, he or she, will come and be a director. But only if I give up my existing option and take a new one for, say, less shares. It is not remotely odd to say, well, the value of my new option is informed by this new directorship. And there's a sufficient connection between the employment, for tax purposes, of this new director and the value I'm getting in my option. So that employment tax is the relevant tax. I'm only going to give up this option if this world-famous person comes. And I'll take the new lesser option. So as my Lord Burrows said, even if it's lesser in terms of shares, it won't be worth less. I'm hoping it'll be worth more. Because of the directorship of this world-famous person. And my respectful submission, that's what's happening here.
Yes, but again, with respect, Mr. Ghosh, I do need at some stage an explanation as to why, on the revenues interpretation, why the solicitor's option is not caught by your interpretation of subsection 1. But this is not the time to do it. I'm happy to let you develop your submission and come back to it.
I can trail what I'm going to say, which is, yes, it might be. There may be evidence that we don't know about where Dixon Minto could say there is other factual evidence, we were wholly indifferent to whether Mr. Noble became a director or not, that may displace, in consideration of all relevant facts and circumstances, the test in 4711. They're not caught by 4713 on any view. And 4711 requires consideration of all the relevant facts and circumstances, so it could be an employment option, an employment-related securities option. It absolutely could be. All I'm saying is I'm not running away from the point.
Well, you may not now be, but I mean, the revenue in the courts below just said Dixon Minto's option was irrelevant. And with respect, it isn't irrelevant. You have to test your interpretation of 4711 by reference to the consequence to someone other than the employee, such as Dixon Minto, if as you say, Mr. Noble's employment is the building block of this whole deal.
And my response, if I give the short response and then return to it in the course of my
Please come to it
submissions,
later, yes.
is that yes, it might be, and there's nothing odd about that proposition. And if you push me, I'd say, well, I can't go further than yes, it might be, because Dixon Minto aren't here in reading other perhaps relevant evidence. But yes, it might be.
Yes. Well, I mean, we're not here to discuss the tax affairs of Dixon Minto, but we are here to give meaning to section 4711.
And my point is that it does not prove too much if the Dixon Minto option also ends up being an employment-related securities option. That does not, in my respectful submission, prove too much.
Well, we'll hear you on that later.
Then, moving on, in June 2016, this option had moved from Mr. Noble's nominee company to Quest, but also holding as nominee. And there's what's described as an ovation to Mr. Noble. As it happens, it looks more like an assignation. Nothing turns on that. And then sometime between June 2016 and November 2016, Mr. Noble exercises his option and he sells the shares at a profit. And that's a point in time after which the 2006 option would have expired. And so, with the court's permission, I'll show the court the relevant documents.
Thank you.
But it's useful, I think, to frame what I'm about to show you with the submissions I'm about to make on 4711, by reason of employment. What does that mean? And 4713, who's made this opportunity available? If it's the employer, well, that's the end of this case. That's 4713. Please, I can take this relatively short. The Statement of Facts and Issues, paragraph 9, MS 35. That's describing this blueprint. That simply tells you in the last couple of lines or so that it was a precondition that Mr. Noble becomes a director, all right. Paragraph 10 that treats and acknowledges and recognizes that the financial package should be looked at as a whole. If you look at the 3 bullet points, equity of shareholders, directors to be diluted, Mr. Noble and Mr. Carnegie to be a director, the 2006 options to be amended. The blueprint is at MS 367. I can take this very short. Paragraph 14 is what tells you this. Paragraph 4 talks about a number of preconditions separately at MS 368. Mr. Noble's to be the executive chairman now, but we know that's a precondition.
As far as the blueprint is concerned, it was envisaged at that stage that Quest's outstanding fees would be paid. And that's clear from the Statement of Facts and Issues and also page 368. But obviously that was departed from at some stage.
I think this is the point we were considering earlier. If this is looking at, as it were,
these are fees outside the option.
Okay. That may or may not have happened.
Yeah, I won't detain you on that. Thank you.
Then the summary, that starts at MS 369. And at MS 373, little 7, you'll see Mr. Noble. He's pleased to be this executive chairman. And then at 375, at little 13, you'll see this new class of shares that are to be issued, D, E, and F shares.
So this is at 375.
375, my lord, yes. If your lordship sees at 13.
D and F shares, yes.
Yeah. And then it's 376, MS 376, paragraph 5, you've got treatment of existing options. And then the class rights of the D, E, and F shares, they're set out at paragraph 7 on MS 377. Now, all of that happened, except we know that it was a new option, not an amendment of the existing option. The contract of employment for your note is MS 387 to 389. The appointment was in March 2007. And then looking at the 2006 option, that starts at MS 293. And again, taking it short, the subscription option is at paragraph 2, that's at MS 296. So that's over 2.5% of ordinary shares. And that's not defined in the option. And the term, as my Lord Lloyd Jones, the point was raised, 4.3 tells you the exercise period is 10 years from the date, or if there's an exit, which is a sale or flotation, at that time, immediately after then. Now, the 2000, I will show you, and I can do it short, but if I can show you the 2007 option, then I'll show you the articles as to why they're different. The 2007 option, that starts at MS 413. These are over F shares. Clause 2 at MS 416. So you've got this option at clause 2.1. There's no consideration for the grant of this option. So the parties are not saying it's consideration for the pre-2007, pre-December 2006 services, anything like that. 2.3 says the existing option lapses, the 2006 option lapses. and it's clause 4.3 that tells you that the exercise price is, the term is 10 years from the date or immediately prior to an exit, sale or flotation. That's MS 417. And then 5.3, it tells you that the option's over F shares. That's MS 418.
This is paragraph 5.
5.3, my lord.
Yes, it's slightly strange because they talk about it earlier on as being ordinary shares, but then later on they tell you that it's the equivalent of F shares.
It's true. The only other mention of F shares is actually on the front piece.
There's 2.1. The company hereby grants to the option holder an option of ordinary shares up to a maximum of 1.5%. But you say that's further defined later.
Well, you have to look at the articles because there's nowhere else to look within the four corners of the option.
Yeah.
But at A, in the recital at 414, where it sets out the authorised share capital, that says there are 3 classes of ordinary shares and that the F ordinary shares are then called F shares.
But I don't want to dwell on this because everybody accepts they've got these F shares and that's what the option was over.
Yes.
And you're told that eventually in 5.3.
Yeah. By the time this option agreement was entered into, D, E and F shares had come into existence.
Not quite. They didn't get around to doing that till later. The articles had to catch up with the grant of this option.
I see. So the first whereas A is not technically, is not in fact correct, but that was what was intended.
Exactly right.
Thank you.
So looking at what the 2006 and 2007 options were over, and I'm saying they're over different things, as well as having being exercisable at different times. The articles in 2006, please, may the court look at MS 258 and MS 259. And with your permission, if you can take this very short, because I think my summary is a fair one. What clause 5 says at 259 is that you've got A and B shares. You've got those. And then 5.5 at 261, what it says, and this is something I trailed, if you've got A shares on an exit conversion event, I'll show you that's defined in the schedule, some of those will go into deferred shares, not going to be worth very much, no voting rights, nothing. That's not true of the B shares.
Which clause is it that says that?
My lady, it's 5.5 at MS 261.
Right.
And the schedule, that starts at page 283, and a conversion event is defined. You'll find that definition at 284. But where we are on this is that the A and B shares, if you look at those, they've got voting rights, they've got dividend rights. The only mention of ordinary shares is at 5.5. Which I've just referred the court in response to my lady.
Your page, which page are we on now?
It's 261, my lord.
261. Yes.
Now, the 2006 articles were amended in November 2006 because there was a new class of C shares. I don't plan to show the court that. It's not relevant to this case. But the 2007, so this is implementing the financial package. Now, MS 423 and 424, you'll see a written resolution adopting these articles, and that's dated 26th October 2007. And the 2007 option was granted on 2nd July 2007. That's why I said in response to my Lord Hodge, the articles had to catch up. But then at clause 5.1, you'll see the class rights for the D, E and F shares set out. 5.1 through to 5.5, that's MS 426 and 427.
Does any of this have any effect on any of the issues?
To this extent, the F shares are different, I say, to the ordinary shares. So the one thing you can't say is that all the 2007 option did was reduce an entitlement to, of 2.5% to 1.5 and nothing else changed. So yes, it's relevant because it's a different option over different shares.
Well, that may help answer a question which I'd like to know the answer to at some point, which is HMRC accept that the 2006 option was not caught by the and it said against you it was all going to be done by just amending that option, and if this had been affected by amending the 2006 option rather than having a new option, then there wouldn't have been a problem because the 2006 option was not caught. But is it the case that HMRC also accepts that if this had been done in 2007 by amending the 2006 option rather than that lapsing and being replaced, that revised option would not be caught by 471?
No, I don't accept that, my lady. What triggers the relevant charge is whether there is an acquisition of a right or opportunity to acquire securities. So it doesn't turn on whether there's a new option or not. You look at the specific right, and the specific option says, is it new? So in my respectful submission, I don't care whether that's done by variation, whether that's done by grant of a new option. What one asks is, has there been an acquisition?
Well, if the variation took the form of a renunciation, what then?
You would ask, A, whether in law that was a new right. If it's a renunciation, the grant of a fresh right, yes, tick. Even if it wasn't, is it a new opportunity?
To acquire rights and securities?
Yes.
I struggle to see how something in the form of renunciation would be the acquisition of a right or an opportunity, but no doubt we can debate the argument.
I'm sorry, my lord. I thought you meant renunciation followed by a grant of a fresh option. If you simply meant, if all that happened was I renounce 2.5 in favour of 1.5.
I renounce 1% of my 2.5% entitlement.
Well, then I accept that's different. I accept then the revenue may not be able to identify a new right or a new opportunity. And that's the limits of 4711 and 4713. The draftsperson, when we get there, what the draftsperson is looking at is to bring within the scope of employment tax, securities options, which have some connection to employment or granted by the employer. And there is a limit. And that's the limit, that if you can't identify the acquisition of a new right or a new opportunity, that is the limit of the provision. That is what makes it justiciable. It may be that as a matter of commercial reality, there may not be so much difference, but all provisions have limits, and that's one of them. That's not this case, but the rationale of 4711 and 4713 is to say, if you get an option and you've got a right or an opportunity, how did that come about? If it's got a connection to employment or the employment of somebody else, somebody other, it's correct that employment tax applies to that on exercise.
But your case is that on the facts here, a simple renunciation wouldn't actually have left a viable option that had any value, putting aside whether Mr. Noble became CEO, because more needed to change than that.
Yes, that's fair, my lady, because the point I'm making is if you look at what's actually happened in this case, you've got this financial package, I've done this point to death, he had to become a CEO as part of that same financial package to make the company more valuable, to get it out of trouble, he gave up his option. He got a new one.
Time is ticking on. We better let you develop your submissions.
I shall develop them, but I'm grateful for the help I'm receiving from the court. Thank you. Please may I look at the FTT decision at MS 149. And I think the most efficient way of doing this, with the court's permission, is I'll take you through the whole of the FTT decision, including their analysis, because that will help actually frame and give context to what I'm going to deliver to the court on my submissions in 4711 and 4713. It'll save looking at it once on the facts and having to come back to it for looking at my criticisms as to how they dealt with the legal submissions. If that suits the court, please may I do that?
Of course.
So please may I pick it up at paragraph 21, MS 152. The previous paragraphs deal with the history of Vermilion, when it was established, all that. Then at paragraph 21, this was before the financial trouble. There was an equity raising exercise. That's what gave rise to the holding company, Vermilion Holdings, being put on top of Vermilion Software. And then at little 2, paragraph 21, little 2 on MS 153, you'll see that it was the company, Quest Consulting, that provided services. And then 24 and 25 tell you why it was that the 2006 options were granted to Quest and the lawyers. It was for additional work, if the court please looks at paragraph 25. Paragraphs 26 right through to 32 sets out summaries of the relevant documents. In my respectful submission, I don't need to show you those. Then we get to the rescue, paragraph 33. That's at MS 155. So 33 to 36 this is what's telling the reader. Vermilion gets into financial difficulty, and it's Mr. Noble, if you look at, please, paragraph 34, it's him who's asked to give an assessment of the situation. 35, it's Mr. Noble assessing the prospect of Vermilion as, yes, the technology is good, but the management approach is put short bad. And then at 36, Mr. Noble continued as an evidence that the bad news was that the company is going to go bust. It was decided. So he's having input into what became this financial rescue package. So at 41, MS 156, this is the precondition that he becomes executive chairman. And a precondition means what it says. None of this is going to happen, the extra money, the debt, the equity, unless you become an executive chairman. And another precondition is at paragraph 44, you need to dilute your option. But they go together. It's the same financial package. Paragraph 46 at MS 157, he becomes a director, all right. 49, you're told, instead of variations, they got new options over these F shares. At 53, I told the court this, between the grant in July 2007 and June 2007, this option had found its way from Mr. Noble's nominee company to the Quest Corporate, but still holding his nominee, and it was novated, so it said, to Mr. Noble. That was at June 2007, already beyond the original term of the 2006 option. That would have expired in February. Sorry, that's not true. But yes, it is. June 2016, that is absolutely true.
Sorry?
The old 2006 option would have expired in February 2016.
Yes.
So the novation is happening at a time after that.
Well,
the heading is incorrect for that paragraph.
Yeah.
Novation.
Yes, the heading should have said the novation agreement of 2016, not 2007.
Exactly. That's what threw me, but that's right.
Yes.
And
So
bracket.
the novation agreement occurred after the 2006 option would have expired.
Yes, my lord.
Or the assignation, yes.
But it makes no difference whether there's an novation agreement or not. I mean, this.
It really doesn't.
No.
So, please may I pick it up at, these are the appellant's, Vermilion submissions in the FTT in paragraph 62 at page 161. And at paragraph 62, and this is their case, it's still their case, the 2007 option was made available only because you already had the 2006 option. And at 63, the result that the 2007 option delivered could have been achieved just by replacing 2.5 with 1.5. And I say those are simply wrong. Turning to discussion, that's the lot on the facts. I mean, I will show the court certain other observations which are said to be findings of fact by the FTT, and I will show you those. But turning to discussion of the issue by the tribunal, that's at MS 166.
paragraph number?
Thank you, yes, paragraph 76 onwards. So the tribunal observes that 78 is only one issue. And actually, what you'll see is that although the tribunal considers section 4711 and considers the two tests in Wicks and Firth, they only do that in order to find out whether 4713 should apply. And you'll see that at paragraph 96 at MS 170. The critical issue in this appeal lies with the interpretation of the deeming provision that's 4713 contains.
That was then, I think, the focus of HMRC's submission. Was that right?
It might have been. I'm a bit hesitant to say it definitely was. But in any event, if the court notes that at paragraph 94, just above what I've just shown you, it said, oh, well, 4713 was described by the revenue as getting rid of a specific problem on what it called founder shares. And what that was all to do with was if I'm setting up a company where I'm both going to be a director and a shareholder, there was a tedious argument to be had as to whether I got the shares by reason of my directorship or directorship by reason of the shares. And 4713 says we're not having this argument. If it's issued by your employer, that's the end of it. When I say as it happens, it's not restricted to that, but that's this case. You are, by the time that the 2007 option was granted, in July 2007, Mr. Noble was already a director of Vermilion. At 99, MS 171, the FTT looks at what is 4711 by reason of employment. And the tribunal looks at the Denning test. If the court looks at 99 through to 103 on MS 171, the tribunal is looking at Lord Denning's test.
Well, Denning's test, as you call it, actually seems to me rather ambiguous, because at one point he suggests but-for cause is enough, but then at a later point he seems to be pretty similar to Justice Oliver's test.
I actually
agree. When he compares the two students at university talking to each other.
I respectfully agree. I think there's less of a distinction than is made between the two in the subsequent case law, like Mares and Hockey. A but-for test is fantastically wide, but as Lord Denning put it, to say, well, if I asked you why did you get this, answer, at least one reason was in Wicks and Firth, my father's employment. That's not at all so far.
Because my father was born or something, which was some sort of remote but-for causation. He's building a bit more into it now.
It's a more subtle but-for test than the traditional kind of naturalistic but-for test. It's true. But the point I'm making is that that's the test that the tribunal's looking at, all right. And then at 104 they say, turning to the facts of the present case, if Mr. Carnegie were to ask Mr. Noble, why did you get the 2007 option, not me? He would say, because I got the 2006 option, which has to be diluted. And I say, well, I say this respectfully, so saying this doesn't make it so. As an application of the legal test, no, you take account of all relevant facts and circumstances. So that's a mixed question of fact and law, as the upper tribunal rightly said. And the one thing that a responsible finding of fact can't do is ignore the precondition that in order to make the company better, you've got to become a director. It's not good enough for you to be a consultant anymore.
I mean, 104, whatever it is certainly not a finding of fact.
I respectfully agree, my lord.
Because, as far as we know, Mr. Carnegie never asked the question.
That's
If
right.
Mr. Carnegie were to ask.
105, she does say, the learned chairman, as a matter of fact, I find Mr. Noble's directorship was not the causa.
That's odd, isn't it? Because we use the legal language, the Latin language of legal causation, and present it as a matter of fact.
I respectfully agree, my lord, and I say it's not a finding of fact. At most, it's a finding of fact in law, and it's wrong. A precondition means that none of this is going to happen. And the last line of that paragraph, the right to acquire the 2007 option in each case emanated from the right under the supplier option. That also, in my respectful submission, is at its lowest odd. The 2007 option didn't fructify the 2006 option.
Well, it's a, use the word emanated from, or that phrase, is a, if it's attempting to paraphrase the actual test in the legislation, then that may not be particularly helpful.
I respectfully agree, my lady. And at 106, she says, well, the revenue would agree. And, well, no, we don't. We weren't asked.
So can I just be clear what you're saying about the relevant legal test? I may be taking you ahead of yourself here, but just in answer to my Lord Legate's question about Lord Denning, you're not suggesting, as I understand it, that the test is but-for causation. You're saying it's something narrower than that, that might be encapsulated by the word legal causation. I mean, what is the submission?
My submission, and I've adopted what I've said in my written case, is that one looks at all the facts and circumstances and asks, is employment here, directorship, a reason for the grant of the 2007 option? That is my submission for 4711.
To me, that sounds like a but-for test.
I don't accept that, my lord. One takes account of all the facts and circumstances and asks, is the employment a reason? Is it part a contributing factor of the facts and circumstances?
But that gives us no insight into what is a reason, as Lord Burrows says, because a reason may be simply but for, or it may be something more nuanced, which I think was what Lord Justice Oliver, as he was then, was trying to get at.
If I could, please respectfully ask the court to hold that thought, because I say whatever the test is, where it's a precondition that you don't get, none of this happens unless you become a director, that fits within the test, however it's described.
I mean, might I just suggest to you, though, that if you are using terminology of reasons, a reason sounds, to me, at first sight anyway, like a but-for test. The reason would sound more like what I understand you to be actually submitting, that the reason,
I don't need to
or
go
the
as far as,
primary reason, or something of that kind.
I'm certainly not saying that, and I don't have to.
Okay.
But this is a sort of philosophical argument that arises in all sorts of areas of the law when you're dealing with negligence and contributory negligence, and the potency of the causal effect of a particular circumstance has to be assessed bearing in mind the purpose for which you're looking at reasons.
I entirely and respectfully agree. And that's why I say, in a world in which 4711 and 4713 are doing the same job, they're saying, is there a sufficient connection between employment and the acquisition of this right or opportunity, so that employment tax is the appropriate tax, not, in this case, gains tax? That's the purpose of this section. 4711 is necessarily, it is very wide. It's by reason of your employment or somebody else's employment. 4713 says, well, if it happens to be your employer, that's the end of that conversation.
Can you give me an example where another person's employment, I mean, there must be just a very straightforward example of where that counts.
The reason, the example I gave earlier, my lord, where I'm an option holder in a company, and that company says we've attracted the services of this person, he or she, who is a brilliant business person. They're willing to take up this directorship. They will make the company terrifically valuable, but part of the package means, I'm sorry, Mr. Ghosh, you will have to give up your existing option to take something, at least on its face, lesser. And I would say, yes, I'm very happy to do that, because that new option will get terrific value from this new director, and I'm getting it by reason of them being appointed as director.
Yes. It would cover the situation if someone wished to employ a brilliant female CEO and conferred the option on her husband, wouldn't it? That'd be a classic example of the employment of another person.
For instance.
Yeah.
Absolutely right.
It's an anti-avoidance thing to stop the provision being evaded by, well, here it was a nominee company, or it could be a family member.
Yes, but to treat, because anti-avoidance carries baggage, it also acknowledges what Parliament is doing. What she has done is to say where the value of your new right or opportunity is informed by the value of somebody else behaving qua director, that is subject to employment tax. Please may I show you some more of this FTT decision. So paragraph 111, MS 173. What the FTT says there, put short, is that section 4713 sets up a presumption, but for this tribunal it's a rebuttable presumption. And I'm saying that's wrong. And at 113, because the tribunal is asking the question, in 112, as Lord Justice Oliver observed, the deeming is to dispense with the deliberation of the nuanced modes of causa and simply to ask, was a right to acquire the 2007 option made available by Vermilion? The tribunal says, in terms, contractual parties in the 2007 option were Vermilion and Quest. The latter acting as nominee come from Mr. Noble. The terms and contents of the agreement are set out earlier and answer the simple question in the affirmative. So far, so good for the revenue. Where in my respectful submission the tribunal goes wrong is in 115 at MS 173 and 116 on MS 174. And 115 is the key to where I say the tribunal goes badly wrong. They say, well, look, we've looked at I paraphrase, but we've looked at 4711. I have said, for reasons which I think are bad, but at this point, who cares what I think? 4711 doesn't apply, so it's anomalous and unjust that 4713 applies. That's a spectacular non sequitur. And that's what a deeming provision is.
But the deeming provision is there, so you don't ask the 471 question. You assume the answer.
Irrebuttably. Yes. Which has already answered the question in the affirmative. You've seen that. So
and the other point about 4713 is when it talks about when it talks about the right of being made available by, it's talking about the person providing it, not what the reason might be for the grant.
Your Lordship, again, typically has anticipated the point I was going to make, which is it's looking at the identity.
The identity of the provider.
Absolutely right. Not the reasons why the provider is doing what they're doing.
Yes. By doesn't mean by reason of something else.
Exactly right. Yes. And that makes sense, given that what the draftsperson is doing in 473 is saying, I'm not having this conversation. I don't want it.
So it's nothing at all to do with presumptions, whether irrebuttable or presumed or rebuttable. We're just talking about a different concept when we're talking about a deeming provision. Is that right?
That's fair, my lord. It's simply that the cases talk about presumptions, rebuttable and irrebuttable, and I don't mind picking up that language. But it's deeming a certain state of affairs to subsist, like it or not. So then you wonder how on earth the revenue could have lost this case. And at 127, MS 176, I mean, there's pages of it, but the tribunal has considered the case law on how deeming provisions work and summarized it at 127, going over the page MS 177. And I don't have much quarrel with that summary. The question is there an anomaly or an injustice? And even if there is, I mean, there isn't in this case, but even if there is there room to disapply the deeming provision? And then at 128 and 129, this is where I do quarrel with the FTT's analysis, because the tribunal is asking, well, having said that it seems to apply, or more than seems to, it just does apply. No, I don't think it does. Why? At 129, she says she agrees with my learned friend that 471 as a whole is definitional. And then she says there's a hierarchy where the lead provision is sub 1. The cohort of subsections exist for the purposes of defining sub 1. The phrase for the purposes of is repeated in little 2, little 3, and little 4. And then it's E, which and this is, please, a respectful observation. E I find incomprehensible. Seen in this light, the deeming provision under 3 ranks equal to 2, 4, and 5 and is subordinate to 1. I don't know what the tribunal means by that. It's not a figure of speech. I literally don't know what they mean.
I don't really understand how there's a hierarchy of these provisions at all. There's not a hierarchy. One just operates in conjunction with the other.
Yes, I mean, 471 sets out a rule, and 473 establishes a counterfactual, which means you don't have to ask the 471 question.
Yes.
But if it worked the other way, if there was a deeming provision that said, in these circumstances, it is not to be treated as by reason of employment, you could find facts from here to whenever that indicated on the facts that it was, but that wouldn't entitle you to impose a charge to tax where Parliament had clearly decided there should not be a charge to tax.
Exactly right, my lady. And that's why I said, in response to, I think primarily questions and observations made by my Lord Burrows, Parliament, what she is doing in 471 is, I've said it more than once, it's capturing to employment tax circumstances where the right and opportunity arises by reason of unemployment, either yours or someone else's. 4713 is saying, and we're not going to have conversations and arguments about what was a reason, what wasn't a reason. There are limits. And one of the limits, the juristic limit, is that one has to identify the relevant right or opportunity to acquire this option. For 4711 purposes, what was the reason? Not the whole. 4713 purposes, who provided it? There may be circumstances where, as my Lady Rose has said, say on the example that my Lord Hodge gave, it's a renunciation. It goes from 2.5 to 1.5, nothing more. Nothing else, no precondition, nothing. Or even if there was. We can't identify a new right or a new opportunity. So the Reverend might say, well, economically it should be the same, but all right, Parliament's given us a limit. We have to live with it.
There is a case somewhere where somebody says something to the effect that in tax law in particular, you can't say, oh, well, if it had been slightly different, then the result would have been different. You have to deal with what you're dealing with and the words of the statute.
I suspect that's probably been said many times by many judges.
Try and see.
But please may I just show you, there's an extract from a case called Price. And if I might summarise Price, because this will help all of us, but particularly me, to make sure I stay within my time limit. This case, Price, was a naked avoidance scheme. What it was to do with was, curiously, the taxpayer wanted certain shares to be employment-related securities. They wanted that. It was necessary because they wanted to manufacture a capital gains tax base cost. And certain gains tax provisions would apply if and only if the shares were issued to an employee. So what was done was that shares were issued by a company to an employee, a director, Mr. Jenner. He assigned it to the scheming taxpayer, the taxpayer who wanted the loss. He wasn't an employee at all. And what was said by the taxpayer was, oh, these shares were issued to Mr. Jenner, who is an employee. That's the end of that question. There's still employment-related securities when he assigns them to me, because they were issued by reason of his employment. What the FDT held was, looking at 4711, these were options. Looking at 4711, these shares were not issued by reason of employment. It was a step in the scheme. Nobody cared that he was actually a director. It wasn't relevant. We're not going to look at that. On 4713, and you need to unpack what the tribunal said. So this extract isn't enough. I will show you the rest of this. What they said was this. The revenue, curiously in that case, was saying, oh, don't take 47132 literally. We don't, this is bad for us. We don't want the scheme to work. When that happens. What was done by the FTT was to say, look, 4713 read literally meant that if you're an employer of anybody at all, it would apply to the recipient of any shares at all. That was simply wrong. They were wrong. That's not what it says. But they went on to say this, and you have to unpack it, the decision. When Mr. Jenner, the director, the employee, got the shares, that was one opportunity, 4713. When he assigned those shares to the taxpayer, that is not the same opportunity as the one that Mr. Jenner got. He, the recipient of these shares by assignment from Mr. Jenner, he was getting a different opportunity, and that's nothing to do with employment, so no. It's not an employment-related security. And the point I'm making here is, implicit is that even in a tax scheme, 4713 bites. Even if the revenue don't like it, it's picking up a point that my Lady Rose made. I will show you this. Anyway, what I've just said is not what the FTT took from Price. And looking at paragraphs 136 on MS 179, so 141 on 180, what the tribunal says is this is anomalous if 4713 applies. It's unjust. And at 141, they say, well, another way of putting it is that the person who made the option available, who or what? I can answer that question by reference to what the tribunal calls the underlying causes. And it's getting further and further away from the text and underlying rationale of 4713.
Well, the problem with 141 is that 4713 was put in place, one assumes, to stop a company, for example, saying, I gave it to him as a shareholder rather than as an employee. And what this is seeking to bring back in is, in what capacity did the company issue the shares? And if that's the case, it denudes 4713 of almost all its value.
Your Lordship can actually pretty much get rid of the word almost, because if 4711 is a gateway, it's not a rhetorical question. How can 4713 ever apply in circumstances that 4711 doesn't? If what's being said is, if you are not employment related within 4711, it is wrong, unjust, anomalous if 4713 catches you. 4713 is a waste of ink.
Well, you could have cases where it's doubtful whether 4711 applies and 4713 tips the balance, but in a case which the FTT felt they'd found, which was that it was clear that 4711 didn't apply, then it's anomalous to deem it to apply using 3.
If that was the function of 4713 to tip the balance in doubtful cases, there's a conversation to be had. That's not what 4713 does. Um, 143 is also, in my respectful submission, odd. That's where the FTT says, well, I would have decided it all completely differently and construed the relevant provisions differently. It's as if it been a tax avoidance case. And in my respectful submission, that is not an appropriate approach to construction. I wonder, please, may I now look at the legal material? I'm very grateful. If I can take its archaeology short, Section 4711 sits in a self-contained part of the tax code, in Part 7, Chapter 5 of ITEPA. So it's distinct, the charge is distinct from general earnings, Section 62, other benefits provisions in Part 3, Chapters 2 to 12. And we're in a place where, if I'm right, this 2007 options and employment-related securities option, all right, then there's no charge on the grant of the option, but there is a charge to employment tax on broadly its realisation, its exercise or its sale, or if you receive a benefit. This is all set out in paragraph 14 of my written case, and none of that should be controversial. Please may I pick up the material at MS 782.
Sorry, page
782.
782, my Lord. So that's section 417 that tells you that chapter 5 is located in this part of the Act, all right. Please then, may I look at 787. That defines what a securities option is. It's section 420, little 8. A right to acquire securities, unless it's all to do with tax avoidance. And please may I just pick up one point here. That's what makes good the point I made in response to the observation by my Lady Rose, that if what had happened was that the 2006 option was simply varied to say it's not ordinary shares anymore, it's F shares, that's a new right. So I don't care whether it was a variation or not. And then please may I look at the section that this case is to do with, section 471. It's at MS 792.
So just, I mean, that reference there in little 420 little 8, subsection 8, which seems to take out of the definition of securities options rights which are granted in a tax avoidance scheme. That rather cuts across what the FTT said about how you still interpret 4711 and 4713 differently if it's in the context of tax avoidance, because it may be that if it's a tax avoidance thing, it's not a securities option at all. Is that how it works?
Yes, the only thing I want to check, those words were put in 2008.
Okay.
So they came after. To be fair to the FT, and I still think they're wrong for all sorts of reasons, but not for that reason.
I think the footnote 13 suggests the words were put in 2006.
That's the footnote I was looking at. But
Well, never mind. It's a small point.
Can I leave the point, because I can if it assists the court, I can find out at the short adjournment and deal with the point and reply. Whether the words were there or not, I say it's quite wrong to construe words in one context differently to the words in another context. But please may I look at section 471.
I suppose one reason for putting those words in is that if it was a tax avoidance scheme, they mightn't want this particular regime to apply because they'd be striking at it in another way.
That would be right, because if the court recollects, there's no charge on acquisition, but the charge is only on one way or another dealing with the option, exercising it, selling it, or getting a benefit. This is all in section 477 through to 480. So yes, you have, this court's dealt with some schemes. UBS is an example. So I think my short response is yes, they may want the grant to buy a tax charge. Now coming to 4711, it's MS 792. So the words are, the magic words are by reason of employment of that person or any other person. Please may I take now, before I get to the rest of my submissions, might the Dixon-Minto option be an option? Yes, it might, in the same way that my option might be an option if the world-famous director may join the company. Yes, it might. And all I'm saying is one has to leave room for Dixon-Minto to argue why it isn't. That's all I'm saying. I'm not running away from the point.
I see. So their option might have been granted because of the employment of Mr. Noble.
It might have been. And for the same reason that in my example, where I'm told get rid of your existing option and take a new one, the new one will be better because we've got the world-famous director. That's not an odd result. That's all I'm saying.
Yeah. It's certainly, given that the whole purpose is to bring within income tax benefits of this nature, security options, which are conferred by reason of an employment, the fact that the solicitors might be caught by 4711 is perhaps a surprising result for the revenue to seek that result. I mean, I'm not making any inquiry whether or not Dixon-Minto were taxed, but the interpretation looks pretty broad if that were to be the case.
Well, it's because the text is broad. By reason of that not just your employment, but any
other person. Well, that was the point. That's why I raised it with you, because below the revenue tried to get out of this difficulty by saying Dixon-Minto are irrelevant, but they're not.
Does the person have to be a person who is subject to income tax? So it wouldn't, if it was a corporation. Well, maybe we
oh God, the answer is maybe for this reason, that this is subjecting the employer company to PAYE. So even a corporate, you can have corporate directors.
Yes.
The rate of tax may be different.
Yeah.
But the nature, the quality of the tax may be very similar.
Yes.
Are there any cases on what's meant by any other person in the context of this provision?
Not that I'm aware of, and I think if there had been, I'd know about it, but I don't think so.
Yeah.
Except, actually, price, because that depended on those options being Mr. Jenner's, and then that was 4713, and then whistled off to Mr. Myers. I'll show you this.
Yes, but you've explained to us, and we can read in our own time, the key rationale in Price was the fact that the opportunity that Mr. Price got from Mr. Jenner wasn't the same opportunity as had been conferred on Mr. Jenner by his employers. Absolutely
right, and I will show you it. Anyway, so that's 4711. And 4713, we've trailed it, and the court's perfectly familiar with its terms and its text. I to read it out. I can therefore go straight to the authorities, and this is really not going to take very long. So Wixon first.
Just sorry, going to A and B, the carve out at 794. If 4713 does not apply because it falls within the unless A and B, does that then preclude 4711 applying, or might 4711 apply on its own terms?
4711, in my respectful submission, could apply in its own terms.
Right.
And they do occupy slightly different spaces.
Right.
So 4711 will apply and catch an option granted by reason of yours or somebody else's employment. And that could be a circumstance where it's well, we've talked about lots of examples, but even if the identity of the provider isn't the employer. (4713), and so, for instance, or a connected person, if the director of the employer company issues the option, that person, if the court could please take this from me, the relevant provisions are 718, 719 of ITEPA, by reference to 913 and 993 and 995 of the Income Tax Act 2007. A director of a company who doesn't own shares or is a minority shareholder is not connected to that company. You could have a circumstance where the director issues a shares or options to an employee and says, aha, this is all outside 4713. But if it's engineered and arises because of the employment of the recipient employee, that's 4711 all right. 4713 is looking at a circumstance, the obvious one, where the grantor is the employer. It's simply unintelligible to say a grantor doesn't make available the option. But it also catches a circumstance where the employer might say to ICI, you grant the option to my employee. ICI is making the opportunity available, but so is the employer. And there's no text there that says it needs to be, the class of persons who's making the right to opportunity available need be only the employer, as long as he employs one of them. So, Wicks and Firth in the Court of Appeal, that's at MS 985. It starts at 985. And I wonder if it's actually efficient to take this short, because the court seems perfectly aware of the Denning test. By contrast, Lord Justice Oliver's test, how both of them say that the cause need not be the sole cause or even the dominant cause. And what's more, it's a test which is wider than the notion of a reward for services. So it's wider than what an old-fashioned tax lawyer would call an emolument. And that, of course, chimes with the new, well, it's not new anymore, the statutory regime in ITEPA, where you've got earnings dealt with in Section 62, and the taxation of these options dealt with in a different part of the code. They're not the same. And again, with your permission, if I just take this next observation short, and I've made the point in my written case, so I'll just repeat it to air it. For reasons which I think need not have arisen, Lord Oliver's test has found more favour than Lord Denning's test in the case law, cases like Mears and Hockey, Wilcock and Eve.
Yes, you set that out in your written case.
I do, my lord, and they're actually rehearsed and summarised in Charman at the upper tribunal, in the upper tribunal decision, which starts at 1413. And in my respectful submission, they're summarised very well and very accurately. That was a case where what was said is, I get shares, there were AB shares by reason of my employment. I swap them for AC shares. Was it open to the first year tribunal to say, well, you got the AB shares by reason of employment, so you got the AC shares by reason of employment? held, yes, tick. Here, you've got the 2006 option, not employment. Everybody accepts that. But, I'm hesitant to repeat it yet again, it's not simply swapping one option for another. It's part of a financial package where you've got to become a director before anything happens. Now, and so what I say about 4711, and I'm really saying no more than I've already said several times in my written case, and also trailed in my submissions on the fact, where you've got a precondition that nothing is going to happen, no new money is going to come in, etc., until you become, unless you become a director, and as part of that same exercise, what's actually happened is that you've got a new option, and you've said yes, because otherwise, if you recollect, please, paragraph 45 of the FTT decision, you can see that your existing option will become bad. Is your directorship a reason to absolutely tap into the observation made by my Lord Burrows? A reason for the grant of the 2007 option. And in my respectful submission, there is no other conclusion except yes, there can't be for a precondition. And that is my short point on 4711. And nothing I've shown you in the FTT decision it hurts me, either in their findings of fact or otherwise. On 4713, again, this is not going to take any time. Who grants the option as observed and acknowledged and accepted by the FTT? Answer, the employer company. And it is, I've said it, it's not intelligible to say if I grant somebody an option which is accepted, I've not made the opportunity of the option available to them. The underlying reasons are, as a matter of text, not relevant in 4713. And there are always going to be reasons why somebody does a commercial transaction. That's what a commercial transaction is. It's driven by facts and circumstances. So on 4713, what the tribunal found was that the grantor of the option, therefore the answer to my question is in the affirmative, should have answered the case. They say, well, no, it's anomalous and unjust. And I've searched in vain, apart from the fact that there's a higher tax rate, why it should be anomalous and unjust. And in any event, that's not for the, in my respectful submission, when Parliament has made it clear the identity is conclusive. That should be, that direction from Parliament should be something the courts should accept and acknowledge. Just for your note, I really don't want to at all engage in a quarrel which I will lose about whether one should talk about presumptions or not. For your note, in a case called Norman, you'll see at 1324, and you will, that's where it starts. And at paragraph 82 of that decision at 1343, you will find 4713 described as an irrebuttable presumption. I really don't want to say any more than that. And in my respectful submission, I don't think I need to take this court to Fowler. This court is perfectly aware of how deeming provisions work. You take the fiction, you look at the text, you ask what does the text say, you then go to stage 2 and ask in principle what makes sense. And if the words let you, if you reach or hit an anomaly or an absurdity, then you ask, is there room for interpretative manoeuvre? That's not this case. We're already debating 4711. And my respectful submission, and this is not overstating my case, you will search in vain for an absurdity or an anomaly where Parliament has said, you said you will take this directorship. It was a precondition of new money coming in. Give up your old option, take a new one. Who's the identity of that provider? Answer the employer. You're taxable to employment tax. And in a world in which you get to exercise that option at a time when the old option would have expired, informed by the work that you have been doing as a director. What is the problem? Now, please, may I show you price? And that's at, 1228. And if the court recollects what the scheme was supposed to be, and I think this is a fair summary, I've said there were shares going to be issued, options going to be issued to an employee of the issuing company, Mr. Jenner. The option would be assigned to the taxpayer who wanted to make the loss, Mr. Myers. And it was important for this scheme that in Mr. Myers' hands, it was an employment-related option. So I'd say it's a curiosity. The taxpayer said it's 4711 or 4713, and the revenue was saying no, 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 no. And you'll see that, picking it up at paragraph, 75 sets out the provisions at 1247. And then the analysis starts at 77, paragraph 77, at 1248. You see at 76, HMRC say that Mr. Myers should not be treated as acquiring an option by reason of employment. 77, since Mr. Jenner was a director, 4713 answers the question. And the taxpayer, Mr. Ewer, he says, well, that's the end of that, 4713. Mr. Brennan says, oh, no, no, it's too literal, if the court sees that at 80. 81, the FTT says, well, we're talking about opportunities rather than rights when we're looking at Mr. Myers. And 81 observes that this was all part of the scheme. So at 82 they say, look, even if you look at Mr. Jenner, who was the director, applying 4711, he didn't get it because he was a director, he was playing his part in a scheme. So it's not by reason of employment, it's not that. Be real, all that. And I'm saying, well, that's not this case. But what about 4713? Now, looking at paragraph 83, They say, well, it's supposed to be wide. I adopt that. At 84, this is where I think the tribunal went wrong. They say, but if you take it literally, it means that any employer who employs anybody at all means that 4713 would tax the recipient of an option, and that's not right. I've interpolated 4713 into 4711 in my written case at paragraph 27. The court has that. In 4713, it has to be the employee's employer who makes the opportunity available. So that's not a problem.
Which paragraph are we looking at now, sorry?
We're looking at paragraph 84 of the decision, my lord.
Oh, yes.
So at 82, they say we're looking at 4711 by itself. You wouldn't say that it was a reason because the reason was the scheme. Right, but then they have to say, well, what about the deeming provision?
Exactly.
Right.
And so they're grappling with this.
But you say they're wrong to say that the situation posited in 84 presents a problem.
Yes, it didn't actually affect how they decided this case, but they're wrong. 4713 applies if and only if the employee's employer provided the opportunity. And that's why at 85 they say the purpose of 4713 is an automatic link, which is a better way of looking at it than presumptions, if the recipient of the opportunity is an employee. So that's the final sentence of paragraph 85 I can happily accept. 3 is limited to the making available of an opportunity to an employee by that employee's employer or person. I'm saying that's true as a matter of text. You don't need to do any work on 4713 to get there. And that's why they say at 86. So let's look at, we need to identify which right or opportunity we're talking about. Mr. Myers getting these shares. And he's saying, well, look, it may be that a different right or opportunity was given to Mr. Jenner, the employee, than to Mr. Myers. At 87...
Well, that seems fair enough, doesn't it?
Completely. I've got no difficulty with that at all. And that's why at 87 they say, well, let's look at an example which isn't a million miles from the example given by my Lord Hodge. But in 88, they say, look, that's why Mr. Myers' opportunity, when he was given the opportunity, he got that as a function of the scheme. It's not the same opportunity that was given to Mr. Jenner. And my point here is that they're not, that's why I said this needs to be unpacked, they're not rejecting the application of 4713 to Mr. Jenner. They're just saying, as far as Mr. Myers is concerned, that's not relevant. We're not looking at that because you got something different to what Mr. Jenner got. So that's why I say in this case is much, much, much simpler. In this case, we've got an option granted by Mr. Noble's employer to him or to his nominee company. And 4713 tells you who granted it, employer, who must have made the right or opportunity available. It must be the grantor, maybe others, but it would include the employer. Is there any reason jurisdically available to the court to displace this? No. And the so-called hierarchy of 4711 and 4713, that, and I make this as a respectful observation, that makes no sense. 4713 operates for the purposes of 4711. You have to read it in, you haven't got a choice. As you see from Price, whether you're the taxpayer or the revenue. So that's why I say the FTT went badly wrong in its assessment of both 4711 in looking at whether 4713 should apply, for the reasons I've given in my case, at paragraphs 34 to 35. The upper tribunal looked at 4711 only, but in my respectful submission, they got it right for the reasons they gave, and I say that in paragraph 36 of my case. But the majority of the inner house, and I don't think it's useful or helpful to reprise what I've said in my case, they replicated the fault of the FTT. What the majority, my Lord Malcolm and my Lord Docherty, what they did was they say in terms that they accept that the directorship and the change in option were both preconditions. They accept that, they say that. Paragraphs 45 and 51, if anybody's interested. They say one would not happen without the other. But then my Lord Malcolm goes on to say, oh, but that doesn't mean that the directorship was a cause or reason of the grant of the 2007 options. You could equally put it the other way around. The grant of the 2007 option could be said to be a condition and a cause of the directorship. And my respectful submission to that is, so what? If it's intelligible to describe the directorship as one of the conditions that gave rise to the and a reason for the option, that's the end of this case on 4711. They also say at paragraph 52, Mr. Noble didn't acquire anything. All he did was give up something. That is simply wrong. It was different shares, yes, with lesser rights. It's a different option over different shares. And what you ask is that different option over different shares, is that within 4711? And on 4713, they replicated the FTT's approach of saying that 4713 is not what they said was a separate route to taxation. And that, in my respectful submission, is also wrong. You look at 4711, you look at 4713, they overlap, but they also can occupy different spaces. And as I've said, if 4711 is a gateway, it's hard, I can't put it to say it's impossible, but I do find myself wondering, for a real-world example, when 4713 could ever apply. I wonder, please, may the court give me just 1 second. Sorry, this is where the tension racks up to make sure that I've said all that needs to be said.
I understood that's what you were doing. I recall doing it myself in the past.
I think you just got the thumbs up, Mr.
Yes. Good. Those are my submissions.
Mr. Ghost, thank you very much. Mr. Simpson.
Obliged, my Lords, Lady. My submission is that the appeal should be refused. I adopt my written case. In short, this case involves Marcus Noble having given up rights that he previously had. In any material respect, he did not acquire anything he did not already have. The issue in my submission only arises because of the legal mechanism by which the transaction was carried out. The reason for it, in short, was not Mr. Noble's employment, but the requirement of the so-called consortium investors that his options be reduced. And as odd as it might be, to think of Mr. Noble having acquired a right or opportunity to reduce his rights to acquire options. My submission is that that right or opportunity was made available either by the so-called consortium of investors.
Sorry,
The so-called consortium of investors, that is, those are the existing shareholders who are willing to put in further funds. Or by Mr. Noble himself. In agreeing to give up some of his existing rights.
Can it be right that the recipient of the option, I mean, the recipient of the option has always accepted the opportunity, otherwise the option wouldn't exist, so he or she has to be a party to it. But are they then always the only person who has made available that opportunity to themselves?
Well, in a sense, lady, it was in fact Mr. Noble making available to Vermilion the opportunity to reduce his options by agreeing to do so in order that the financing package could go through.
But you'd say that in some circumstances the recipient of the option can make the option available to himself.
On the odd facts of this case, lady, because
by being so brilliant, he made this available to himself.
lady, the point is that Mr. Noble already had options.
Yes.
He, in a sense at least, made available to Vermilion the possibility of reducing his entitlement. And it was not, in my submission, Vermilion who made available to him an opportunity to reduce his entitlement to shares. But my primary position, it was the consortium of investors who required a reduction in Mr. Noble's share options. The fact that the legal mechanism chosen for reasons of simplicity and keeping the cost down was cancellation of the existing options and the grant of new options. It does not, in my submission, mean that Vermilion who granted those new options made available to Mr. Noble a right or opportunity to acquire them.
Well, I mean, there were two elements. The consortium required the reduction of the entitlement from the 2006 option, and the mechanism adopted was cancellation, but also the creation of a right to acquire a new securities option.
Yes, my Lord, that's entirely correct.
But that right to acquire the new securities option was, or the offer of it to Mr. Noble was something made available by Vermilion.
Well, it was something in my submission agreed between Mr. Noble and Vermilion.
Well, Vermilion would be the issuer of the shares, and they were also the ones who contracted to give the option.
Yes, Lord. So what we have to look at in terms of subsection 3 is who made available the right or opportunity to acquire the option. Now, it's not, in my submission, who granted the option. If the test were simply who granted the option, in my submission, legislation could quite easily have said that.
Well, a right to acquire a securities option.
Yes, Lord. So we're looking at something, a right before the agreement is entered into. Because the option is not the right that we're looking at when we're talking about who made something available. It is in the context of this case, we're looking at the right or opportunity to enter into the replacement option agreement.
We're probably looking at an opportunity here rather than a right, so are we not? I mean, didn't have a right
Yes.
to enter into the new option.
Well, perhaps not. Well, in my submission, the only thing that he would not have had a right to was a slightly longer period of time. Otherwise, in terms of the original option agreement, Mr. Noble first had a right, or a power, I suppose, if one wants to look at it in more Hofeldian terms, to waive or renounce part of his rights under that. He could, for example, execute a document saying, I renounce 1% of my 2.5%. It would be a bit more complicated than that because there were a variety of percentages depending on hurdles. He could say that. So far as F shares are concerned, in the usual way, the 06 option agreement, the original option agreement, provided for changes to it, should that become necessary because of, for example, a reorganization of the company's share capital. That is in clause 6 of the original option agreement, which appears at page 298. 298.
298.
98 or 18?
298. 298. Sorry, my lady.
Do you think that there's only one person in any given situation who is making available the right or opportunity? Because Mr. Gosh seemed to be suggesting there can be a number of people who make the right or opportunity available, and as long as one of them is the employer, that's enough for 4713.
Lady, I wouldn't wish to exclude the possibility that people come together. And I suppose in the present case, of course, the position is that it was the consortium investors who are a number of people together who were, who were making available the right or opportunity to reduce Mr. Noble's options so far as he didn't have that already.
But when you posit them and Mr. Noble himself, are those alternatives? They couldn't both be making the right or option available?
On my submission on the facts of this case, they probably are alternatives. I can't say there's no situation in which one couldn't regard a number of different people in different capacities making available a right or opportunity to enter into an option agreement or to acquire securities options. But in my submission, lady, the HMRC's case from the first tier tribunal onwards, and I do say that I think being the only counsel here today who wasn't the first tier tribunal, at the first tier tribunal, HMRC did not put their case on subsection 1.
No. Well, I think that's fairly clear. Reading the first tier tribunal's judgment, it goes straight into subsection 3.
Yes, my lord. Yes.
Why does that matter now?
It doesn't make any difference now. We had that fight at upper tribunal in the inner house, and I'm not re-raising the point.
No, I mean, your attempt to exclude 4711 didn't succeed, so they're both before us now. But it seems, reading the judgment, you are right as a matter of fact that the revenues case in the first tier was on subsection 3.
Yes, and moreover, the revenues case at that stage was that subsection 3 was satisfied, as one can see from the first tier tribunal decision as well. The subsection 3 was satisfied simply by the fact that Vermilion was the grantor of the option. That was enough on HMRC's case at that stage. It seems more or less to be HMRC's case still. In my submission, that simply can't be right, because if that was what was going on, then the subsection 3 would be worded very differently.
Because, sorry?
Subsection 3 would be worded very differently. It would simply say if a securities option is granted by a person's employer to that person, then it is deemed to be granted by reason of available by reason of employment.
Well, it may suggest that they're trying to, in subsection 3, be wider than just the grantor of the option, because the opportunity to acquire a securities option it has to be made available by the employer or a person connected with the employer. Now, the person connected with the employer wouldn't be the person probably who actually granted the option if the option was granted by the employer itself.
Yes, indeed, my lord. So the point is, the section isn't looking at the grantor. The section is looking at something different.
Or something more wide.
Well, in my submission, at least certainly different.
Well, it seemed to me it would include the grantor of the option, but it goes wider than that.
Well, it's at least on. It can include the grantor of the option if, on the facts of the case, the grantor is the person who has made available the right or opportunity to acquire the securities option. My submission is that it's not in every case that the grantor will be a person who has made available the right or opportunity to acquire the securities option. Now, I could reasonably easily agree that in any normal case, a grantor does make available the right or opportunity, for example, by making an offer to its employees to take up share options.
Well, sometimes I think in a case I did about employee options, a little company or trust is set up, which deals with granting options under a share scheme for the employees.
Yes, Lady. So in that scenario, my submission would be that if it's the trustees who grant the option, then first, they're not the employers. The employer is not making available the right opportunity. It may be.
Well, the employer is making available because they direct the trustee as to who should get the shares.
If made, well, I suppose that would. If that is a scenario that the employer is making a direction to the trustees, then yes, that might meet the test. But of course, it might be the case that in some trusts, all the employer does is provide a letter of wishes, so as not to try to fetter the trustee's discretion. My submission is that's a reasonably normal way of structuring that type of transaction. In that case, it is the trustees who are making available the right or opportunity to acquire the shares, to acquire the securities option. So in my submission, on the present case, what are unusual facts? The legislation doesn't bring Vermilion within subsection 3 simply by virtue of the fact that the Vermilion was the grantor or was a party to the option agreement.
I understood you to be saying that if all that had happened was that Mr. Noble had agreed to relinquish 1% out of the 2.5% of the shares he already had an option over, then there wouldn't have been any right or opportunity made available.
Indeed.
But you're accepting that in this case there was, by reason of the slightly longer term, is that right?
Yes, my Lord. And for the avoidance of doubt, I don't accept that the change in share classification by the articles is something that indicates a different right, because the possibility of changes to the original option where...
Is covered by Clause 6, is that what
Precisely,
is that?
Precisely.
Where do we see that?
Well, Clause 6.1, the company...
298.
298.
Yeah, sorry, page 298. Sorry. So 6.1, company undertakes that shan't take any action and shan't recommend to shareholders any resolution, etc., to affect any the final term is variation or other reorganisation in the company's issued share capital and or the rights attaching to it, without the prior written consent of the option holder, with various exceptions, none of which is relevant.
So they couldn't do it without consent?
Indeed, indeed.
So
does it follow that if they did it with consent, it isn't a new right?
Well, I would submit it. I would submit, my Lord, it does, because, of course, consent is not to be unreasonably withheld. And in my submission, that at least implies that Mr. Noble would be able to, as part of his existing right, insist on such amendment to it as would be necessary to reflect the changes to the articles.
Right, but do I understand from your answer to my Lord Legate that you accept that this is not simply a renunciation of the 1% because of the longer period for which the 2007 option was valid?
Yes, ma'am, I accept that the longer period may mean that the changes, if done by amendment, would not necessarily have been simply the same right, but...
You're accepting, as I understand it, that an opportunity to acquire a securities option was conferred, but you're saying that the revenue is wrong to say Vermilion was the party that conferred it?
Yes. Yes. Yes, that is the legal the legal submission, and in support of that, I say that, leaving aside the slightly extended period, this could all have been done by way of amendment, without any opportunity to acquire a right, without a right or opportunity to acquire securities options having existed at that time.
Don't we have to focus on the way in which it was done?
Indeed, indeed, my lord. Yes, yes. And the point is, it's that we're only here because of the way in which it was done, which is something that goes along with tax law.
You were saying that wasn't. You accepted that's not the case. I'm a bit confused now about what you accept and what you don't accept.
I apologise, madam. I'm sure it's my fault. My position is, number one, the reduction could have been achieved by waiver or amendment without any new right to acquire securities being created. Number two, the necessary changes to the option agreement brought about by the reclassification of the share capital in the company could also have been achieved without any new right to acquire securities being created. Now that's the difference between my learned friend and myself. In my submission, clause 6, to which my learned friend didn't refer, of the option agreement, supports that position.
Well, I wonder if it does. I mean, clause 6 simply says that you can't make the changes without your consent. Non-constat, that if you do consent, you don't get new and different rights.
Well, Lord, it requires, without the prior written consent of the option holder,
yes,
such consent not to be unreasonably withheld or delayed.
But the consent gives rise to a new deal in respect of new shares.
Well, in my submission, it would give rise simply to an amended right, amended to the extent necessary to reflect the changes in the Articles of Association. And so far as the intention is concerned, 6.2 identifies that the purpose of the clause is to ensure that the option holder enjoys the economic the economic benefits of the option are preserved. What I do accept might not have been able to be done by amendment or waiver is the extension of the term.
Well, it could be done by amendment, presumably, but would it not be the conferring of a new right?
Yes, Mark, so that's what I was meaning. It could have been done, it could have been achieved by amending the document, but whether that would have amounted as a question of law to the acquisition of a right to acquire securities within the meaning of section 420 subsection 8 is a separate question. That's a question of degree.
But But you don't have to make a definite submission on that because you say in any event Vermilion was not the one making it available, or not
Yes.
the one making it.
Yes. The question we have to ask is not were the options identical or could it have been achieved by amendment or waiver. The question is who made available the right to opportunity to acquire it, and was the right to opportunity available by reason of Mr. Noble's employment as a director. If that's a suitable time to pause.
Yes, the court will take a short adjournment at this point. Thank you very much, Mr. Simpson.